Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about vicarious liability for misconduct by police officers. Cases that should have gone to the Supreme Court of Canada, but didn't. The City of St. John, New Brunswick was sued by a large number of people in a class action on the basis of misconduct alleged by one of its police officers who had committed alleged sexual violence against a large number of people. The city was sued because they were effectively the employer of the police officer at the time, as the police officer was acting in the force in the city at the time. And the city argued that it shouldn't be vicariously liable for conduct of its police officer employees, particularly where that conduct falls outside the scope of their duties. Unfortunately, the court disagreed and found the city liable and ordered the city to pay damages for the sexual misconduct committed by this officer. This case raises very important issues because vicarious liability in employment is a significant issue, and the Supreme Court of Canada doesn't consider enough civil litigation cases as it is, much less cases that deal with vicarious liability of employers. And when it comes to police officers, who are given a lot more power, but also a lot more leeway, and whose relationship to the city as far as the employment relationship is really tenuous in many respects, this case raises issues about who is properly the person to be sued in these types of instances. It's not as though the city was endorsing the police officer going out and committing sexual misconduct. And the city likely couldn't have done very much about it because, generally speaking, when police officers are dealt with by cities, they're dealt with through the police board, which then deals with the police through the police agency itself. The police have their own unions, the police have their own internal discipline processes, and there are external civilian oversight processes in place in many places as well. So because there are all of these layers to protect the public from rogue police officers, and because all of those layers essentially limit the ability to which the city can control, manage, supervise, and hold accountable its individual employees, even though they may just work for the city on paper, and their police department may receive funding from the city on paper, should that make them liable? Should there not be individual liability for the officer who committed this misconduct? And shouldn't that liability be borne solely by the officer or by the police department themselves, as opposed to making the city liable when there are this many steps of accountability, of removal between these two entities? It's unfortunate that the Supreme Court of Canada didn't really take the opportunity to address the nuances of these types of employment relationships, because they are often common in other types of situations where corporations own corporations that run other corporations, and employees in various corporations may do things that are unacceptable. Determining who is ultimately liable and finding that pathway requires good guidance from the Supreme Court of Canada, and it was an opportunity to really do this in a significant context of police accountability that doesn't get a lot of light shone on it by the Supreme Court of Canada when it comes to civil accountability for police officers. Hopefully it doesn't take another horrific set of facts like this for the Supreme Court of Canada to have the opportunity to deal with these issues, to address them, and to determine who really should pay when police officers act badly. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brunswick for putting together these videos. Please like, subscribe, and share with your friends.